My name is Henrik Bjørnebye. I'm a law professor at the Faculty of Law, University of Oslo, Scandinavian Institute of Maritime Law, where I also head our Department of Petroleum and Energy Law. And I work primarily with electricity markets and EU law. My presentation today concerns the extension of the EU energy acquis to non-EU member states. And the background for this presentation is that we have for many years now seen that we are getting an increasingly ambitious EU energy union policy, and that also translates into an ambitious EU energy law. Now, and with a comprehensive and complex regulatory situation, the need for the relevant and strong institutions are also necessary in order to follow up, to supervise, and to enforce the law. And I think this is an important background why we have seen institutions such as the Agency for the Cooperation of Energy Regulators, the ENSOs for electricity and gas coming, and as we see in the clean energy package, it has also been proposed to establish a separate institution at the EU level for the DSOs, the EU DSOs. The emergence of these EU energy institutions raises some questions as to their reach and applicability also for non-EU member states who are part of the internal energy market. And those institutional challenges is the topic that I would like to address in this presentation. And I will make this presentation in three parts. I have an introductory part, a background part, and then I will look more particularly at the institutions and their competence and their applicability to non-EU member states. And finally, I will draw some conclusions before our Q&A and discussions. Let's see. So, as a background, I think it's important first to emphasize that the internal market comprises more than just EU member states. First, we have the EEA agreement, which was signed in 1992 and came into force in 1994, which essentially extends the EU's internal market also to the EFTA states, so in practice Norway, Iceland and Liechtenstein. So they are also members of the internal market, and through that the internal energy market in particular, since the internal energy market has been based very much on internal market legislation. And then we have the energy specific initiative through the Energy Community Treaty, which extends the energy acquis to at present 9 contracting parties outside the EU. So a cooperation of a different nature, since it's not sector overarching, but rather relating to energy in particular. I should emphasize right away that my expertise lies particularly in the EEA agreement, and I will focus primarily on those challenges, but it is my understanding that some of these challenges will also arise or can arise for the energy community, although in a bit of a different context, and I will be happy to discuss those challenges as well afterwards. And then as a third point, of course, we also have the questions of what will happen post-Brexit for the UK, what kind of cooperation within the sphere of energy will be necessary there, and whether it's possible to draw inspiration from the other examples that we already have, such as the EEA agreement and the energy community. Now, I think that this issue raises both legal challenges and what I've called market challenges, and perhaps the two EFTA states, Norway and Iceland, can provide an example in this respect. With respect to legal challenges, there's a question of whether the EU legal rules, the Energy Acquis, should apply correspondingly to non-EU member states, the substantive provisions as well as the institutional provisions. And that for Norway and Iceland will be solved through the EEA agreement, where in practice most of the Energy Acquis will apply, and in some instances there might be some questions. I will try to revert to that as well. So that's the legal part. But then we also have the technical economic part of this, where if we look at Norway, Norway is a fully incorporated part of the Nordic electricity wholesale market with interconnectors to the other Nordic countries. We also have an interconnector to the Netherlands. One to Germany is currently being built. So Norway is in practice an integrated part of the Nordic and the EU electricity market. And in that situation, it is of course very difficult to perceive a situation where you have different governance structures for a country as Norway and other neighboring countries when they are part of the same market. So that's also an important part of it. While if you look at Iceland, for example, which has no interconnectors to other EU EEA member states, the legal aspects are perhaps more important than the more practical market aspects. So since I'm talking about the EU Energy Acquis, I should just briefly also clarify by what I mean by that term. I mean both the substantive rules in primary law, in the Treaty on the Functioning of the European Union, such as the free movement rules, the state aid rules, the competition law provisions, which we have seen in practice that are also very important to the development of energy markets. The Åland Vindkraft and Essent Belgium cases are examples within the free movement of goods sphere. State aid rules have played a very important part, for example, with respect to incentive schemes for the construction of new renewables. Competition law has played an active part in many cases by the Commission within the energy sector, both within gas and electricity. And for these provisions, we have corresponding provisions in the EEA agreement, which are interpreted in the same way as the provisions of in the treaty. And with respect to the energy community, there's a separate chapter there in the treaty implementing at least the competition acquis, namely the state aid and competition rules within the energy sector more specifically. And then we have the gradually expanding secondary energy market legislation. And one could question how to really define energy market legislation. In this presentation, I've included all legislation of relevance to the energy sector, and in practice that would imply in particularly measures adopted under the internal market provision of the treaty, under the trans-European network provisions, under the environmental title, and also of course the energy title of the treaty. And just very briefly to sketch an overview of what secondary legislation we are talking about, I have used just a figure which has been drawn up by the Norwegian Ministry of Petroleum and Energy to give an overview of the Norwegian legislation for the sector, where we have the upstream part, the production part, represented by hydropower here, since hydropower is very important in the Norwegian energy mix, amounting to 96% of the production capacity in the Norwegian system. And we have the market, the transmission, distribution, and supply. And you see the Norwegian legislation here, but I would like also to just add the EU legislation as an illustration. So at EU level, we have the market legislation adopted on the basis of the internal market provision, in particular the third energy market. I have included the electricity market provisions here, but we also have similar or corresponding legislation for the gas market, of course. We have the network codes as a very important part in practice of the internal market legislation, as they have been adopted on the basis of the electricity regulation. and where methodologies are now being developed pursuant to the network codes. We have the environmental provisions, in particular the Renewables Directive. We have a new EU ETS directive affecting the sector. I have included here the Water Directive from 2000 as well, which is a sector overarching directive, obviously, but it has importance for countries with large hydropower resources, such as Norway. We have the secondary legislation adopted on the basis of the energy title, where we have quite a diverse legislation. REMIT as a market regulation on transparency, and then we have the energy efficiency initiatives, such as the Buildings Directive and Energy Labeling Directive, etc. And then we have the Trans-European Network legislation, in particular the infrastructure regulation. So it's quite a complex and comprehensive set of legislation, where most of it is now also proposed amended by the Clean Energy Package. And this regulatory situation calls also for the right institutional structure, which I will revert to. I would like to, as an overview, just briefly mention some overall challenges in extending this energy acquis also to non-EU member states. And we can divide these challenges into substantive parts and institutional parts. And by substantive parts, I mean the content of the legislation as such, and the rights and obligations. And by the institutional measures, I mean those measures which in particularly sets up or requires something from the relevant institutions. Now, the substantive parts, which I'm not going to touch upon in detail in this legislation, in this presentation, obviously also raises some questions, such as, for example, the lack of influence of non-EU member states in the drafting and legislative process at the EU level. For example, if we look at the third electricity market directive and the unbundling alternatives there, it's quite clear that the needs of different member states have played into the legislative process, while a non-EU member state will not be part of that, and hence will rather have to implement the legislation as it is adopted. And this is, of course, a result of the whole process, where a non-EU member state is not part of the legislative process. Technical amendments might be made afterwards, but only to a certain extent. A question of legal relevance might arise. For example, the EEA agreement as an internal market agreement. It is not entirely clear whether all legislation adopted on the basis of the energy title of the treaty, which to some extent also goes beyond the internal market, will in fact be relevant under the EEA agreement. So that's a separate issue. And then there's the issue of delayed implementation, where those legislative initiatives adopted at EU level will later have to be implemented in other countries. One extreme example is the third energy market package adopted at the EU level in 2009 and not actually adopted in the EEA committee until 2017, and only in 2018 being accepted by national parliaments, EFTA parliaments. So it's been almost 10 years since the adoption at EU level, which obviously also could raise some questions when you have different regulatory situations for different countries, although just for a certain time. And then there is the institutional measures. Sorry. And that could be measures which relate to requirement for national institutions, such as independence requirement for national regulatory authorities, and it could be institutional measures relating to the establishment of specific EU energy sector institutions. And this latter point is what I would like to look at in the following. Which brings me to the institutions. Now we have at EU level general institutions such as the Parliament, Council, Commission, and the Court of Justice of the European Union. And here we have parallel institutions at the EEA level through the two-pillar structure, such as the EEA Joint Committee, where EFTA states and EU states participate. And we have specific EFTA institutions such as the EFTA Surveillance Authority, ESA, which is a parallel to the European Commission, and we have the EFTA Court as a parallel to the Court of Justice of the European Communities. At energy community level, we also have general institutions, although they, of course, and only relate to energy-specific matters, as it is an energy community cooperation, such as the Regulatory Board of the Energy Community, for example. And then we have the energy sector institutions, and that is what I'm going to look at in the following, where we have ACER, we have the ENTSOs, and we have the proposed EU DSO. And I'm going to look in particular at ACER and the ENTSOs, actually in a reverse order, and look at the challenges they raise. Now, first, the ENTSOs, objectives and functions. They were formally established by the electricity and gas regulations from 2009 in the third energy package. And the purpose is, in essence, to promote the completion and functioning of the internal energy market, both within the sector of electricity and gas. They take over from earlier, more informal institutions, but it's being more formalized in the third energy market package. And the most important function of these ENTSOs is in practice to draft network codes. And I believe that given how comprehensive these network codes are, this task is very, very important in practice. So the ENTSOs de facto has a very important responsibility in drafting these network codes. But since they are finally and formally adopted by the Commission as Commission regulations and not adopted by the ENTSOs, we're in a situation where they formally have no legal powers to adopt binding decisions. They are just proposing drafts, which is actually puts them in quite an interesting situation, I think, both in terms of EU law and in terms of extending the energy acquis beyond the EU, because then you have these institutions which have very important responsibilities, but formally no binding decision-making powers. So how should they then apply to countries beyond the EU? Now, if we look at it in practice, ENTSO-E for electricity have 43 member TSOs from 36 countries, and they also include the TSOs from the EFTA states, such as Statnett from Norway, and also for some energy community states. ENTSO-G, 45 members from 26 countries. Here, EFTA and energy community states are observers. So if you look at ENTSO-E, for example, the non-EU member state TSOs are also members and participate in these procedures. And as far as I can see, there are no legal problems, either from the EU perspective or the member states outside the EU perspective to this approach. And from a governance perspective, they also should be members, because given that they contribute to draft so specific provisions for all of the markets, it's important that they are all the TSOs are part of this. So we are in the situation where non-EU membership is in a way less challenging, but that is not because these institutions do not have important responsibilities, but because they have no formal powers to adopt binding decisions. Now if we look at ACER, the situation is a bit different. Also established by the third energy package through a separate regulation. The purpose is to assist the national regulatory authorities, essentially. And where necessary to coordinate their actions. If we look at their functions, they have more informal functions in terms of cooperation, ensure cooperation between national NRAs, to issue opinions and recommendations, to assist in regulatory development. And in all these issues, one might say that membership from non-EU member states would really raise the same questions as membership in the ENSOs. But then ACER also has some formal decision-making powers. Just to look at those decision-making powers in somewhat more detail, they can in some instances adopt decisions on technical connection issues under the internal energy market legislation, Electricity Directive and Gas Directive. In cases where national NRAs are not able to agree on the terms and conditions for the use of interconnectors, ACER can adopt a binding decision, and also in cases where the NRAs so request. Similarly, if national NRAs are not able to come to a decision on exemptions from third-party access for new interconnectors, the agency might, in some cases, give a binding decision. And finally, ACER has tasks pursuant to other legislation, such as the infrastructure regulation, REMIT, and the network codes, where I believe that in particular the tasks under the network codes is important, where ACER, in some cases, if the national regulatory authorities are not able to agree on the methodologies, for example, ACER might give a binding decision, such as we have seen, for example, in the case concerning the definition of capacity calculation regions, where the Austrian regulator did not agree with the other regulators on the definition of the regions. Now, so what are the challenges in extending the ACER model to non-EU member states? Well, the main challenge relates to these binding decisions. And if we look at it from the EU member state level, it's a challenge and very difficult to perceive that actors from non-EU member states should be able to have voting rights for a decision that binds EU member states. And correspondingly, for a non-EU member state, it is difficult to accept that the EU member states and actors from EU member states should be able to vote to bind the non-EU member state. So this creates a challenge as to how to align this for non-EU member states. What makes it perhaps a bit easier in practice are the limits in powers under EU law in delegation of authority to EU agencies such as ACERs, the so-called Moroni doctrine, which is complex, and I'm not going to go into that in detail, but in essence it says that it is not possible to delegate discretionary political powers to agencies, which in practice would mean that there are limits as to what kind of decision-making powers which might be delegated to an agency, which might make all of this less controversial. But still, the agency, ACER, has some decision-making powers. And how should those be dealt with? One alternative, just thinking generally, could be to just say that, well, those provisions where ACERs may issue a binding decision, they should not be applicable to the non-EU member state. But that is quite difficult, since ACER makes decision on substantive law, which is also important for the EU energy market to function, such as provisions on the terms and conditions for the use of interconnectors. So it's not really a good alternative. Another approach would be to say that, well, we need separate agencies for the non-EU member states. But from an institutional perspective, it would be a quite sort of heavy option to have separate institutions for the energy sector for a cooperation such as the EEA agreement, which would then apply only to a very limited number of countries. For the energy community, this is a bit different, since it is an energy cooperation, and we there have, for example, the regulatory board for the energy community already. And then the third option, which is the option chosen under the EEA agreement, is to have the powers exercised by already existing non-sector related institutions, and not have separate energy institutions. So if we look at just briefly the EEA approach, the approach here is that the decisions corresponding to the ACER decisions in the EU cooperation, they are to be formally adopted by the EFTA Surveillance Authority, ESA. But they will be adopted on the basis of a draft from ACER. And a close cooperation between ESA and ACER is facilitated. And then, for constitutional reasons, the decision by ESA will not be directly binding for the actors in the member state, but rather directly binding for the national regulator, which will then have to turn around and adopt corresponding decisions for the national actors. So it's quite a pragmatic approach in a way, in order to obtain the same objectives as we have for the EU cooperation. Now, if we very briefly look at the energy community approach, which I should emphasize I'm not an expert, the situation is a bit different, because there the regulatory board of the energy community adopts recommendations rather than binding decisions, as far as I understand, for those issues which correspond to the decisions made by ACER. Now, I believe there are advantages and disadvantages with the different models here. If we look at the EEA model, an advantage is that the existing institutions are applied. So from a capacity perspective, it's sort of an easier approach. A disadvantage is that you really then have institutions of a bit of a different nature adopting the same decisions for EEA and the EU. At the EU level, you have an energy agency. At the EEA level, you have a more general surveillance authority corresponding to the Commission, really. And then there is, of course, a question whether the EFTA Surveillance Authority in practice really has much discretion here, since they are going to adopt their decision on the basis of an ACER draft, whether it is really in practice an ACER decision, which is then adopted by the EFTA Surveillance Authority. But it should be said that the present structure does give a rise for disagreement to be taken to a higher level. So at least formally, the EFTA Surveillance Authority may not agree with the ACER decision. And for the time being, at least in my opinion, I think it's difficult to perceive of other solutions than what has presently been chosen here. So just to wrap up and conclude before our Q&A and discussion. First, we are in a situation with an ambitious EU energy policy, as I started with, and this has resulted in a large volume of legislation, and we need the right and relevant institutional structure to deal with this, to deal with supervision and enforcement, etc. And then the question is, how do we go about this also for non-EU member states? I think it's interesting here to look also at the relationship between substantive law and the competence for institutions to supervise this law. Because in my opinion, in practice, it is really the substantive law provisions, the contents of the legislation, the contents of the network codes, their applicability to the terms and conditions for interconnectors, etc. That is really the important point in practice, I believe. But in reality, it seems that it has actually been easier to adopt those kinds of substantive provisions to non-EU member states than to actually extend the institutional structure. Because the content of the substantive law is, in my view, more important than the question of which institutions which has the competence to oversee the different parts of the substantive law. But nevertheless, the latter point has been more difficult in practice. For example, we have lately had a huge controversy in Norway concerning the institutional structure with ACER and the EFTA Surveillance Authority. It's been a massive public discussion, unlike anything we've had on the implementation of substantive provisions before. And of course, what is particularly challenging in this picture is the institutions with competence to adopt binding decisions such as the ACER. The membership in the ENSOs has so far not turned out to be so controversial. And when it comes to the institutions that has binding decision-making powers, in practice ACER, in my view, the approach so far, at least under the EEA agreement, has been a very pragmatic one. One basically tries, as far as it is possible, to find pragmatic solutions to a rather difficult legal situation. And so far it has worked fine. But the question I would like to pose is really, as this regulatory system further develops and becomes more comprehensive, are there limits to this pragmatism? Is it possible to continue in the same manner also for non-EU member states, or do we need to think in different fashions in order to overcome also institutional challenges? So thank you very much for your attention. That was my presentation, and I will now be very happy to go to the Q&A and discussion part. I will just review the questions here. Okay, I have a first question here. How would you understand the phenomenon Europeanization of energy law in the Energy Community Treaty participatory states? And what are the key instruments to implement the energy acquis domestically in non-EU countries? Thank you. Well, thank you. That's a very interesting question. I should again emphasize that I am not really an expert on energy community law and the Energy Community Treaty. But the way I understand the treaty, it essentially incorporates the full energy acquis, as far as I understand. Also, at least some of the network codes adopted on the basis of the third energy package has already been incorporated. So one key instrument will be the implementation processes as such, and in that respect it seems to me that it is not very unlike the process under the EEA agreement, where formally as new treaty obligations one takes on new pieces of secondary legislation. And then the question is how to follow up on this institutionally, where the energy community setup is a bit different than the EEA setup, in particular, as I understand that through the fact that one has this regulatory board for the energy community consisting of national regulators. And then there is the question of the decision-making powers there, which I understand that they make recommendations rather than binding decisions, which is a bit different from the EU approach. Next question. Now that Norway has adopted the third energy market package, is it possible that the conditions of participation of the Norwegian NRA in ACER will change? Following the recent developments, would it be possible that the Norwegian NRA could get a seat at the board of regulators? Well, what has been decided is essentially that the Norwegian NRA will be a part of ACER, in practice will participate in the different processes, but they will not have voting rights. So will not have competence to vote in the binding decisions, and hence we have the specific EEA structure with ESA adopting binding decisions. But apart from that, the Norwegian regulatory authority will also participate. I hope that was answering your questions so far. Please let me know if you have follow-up questions. A next question. What about the Mediterranean region? Is it possible to create a framework for the application of the energy acquis in the southern and eastern shore countries, leveraging and reinforcing existing institutions such as MEDREG or the UFM? I must apologize. I'm not wholly familiar with these institutions. At the outset, I would believe that it's possible. It's a political question, of course, whether it's feasible. But it should be possible to at least draw some inspiration from in particular the energy community work, I would suppose. But I have not looked into that matter for my part. For the next question, what if an ACER decision is challenged by the court? in an EU internal border or between an EU and an EEA border? What will be the process? And will we risk different decisions by the courts? If it is between an EU and EEA border, for example, and it affects both an EU and an EEA state, well, then the situation will be that the ACER will hand out a decision for the EU regulators, member states, and the EFTA Surveillance Authority, a parallel decision for the EEA member states. And under the EEA structure, the decision can ultimately be challenged before the EFTA court, and under the EU structure, the situation can ultimately be challenged before the Court of Justice of the European Community, European Union, sorry. So what will be the process, and will we risk different decisions by the courts? Well, if we should end up in a situation where we actually have two different court proceedings, I would assume that it would be possible to stay the procedure for the EFTA court, as the EFTA court will ultimately also be very careful to consider the EU court's reasoning and conclusions for the purposes of homogeneity under the EEA-EU cooperation. So I believe, at least in practice, that would be the situation. And then it's possible, of course, to envisage that a process is coming up only for the EFTA court, and then you later have a separate case which comes up for the EU court, where the EU court rules otherwise than the EFTA court. And then the situation would be just as for other cases where this situation might arise, and then there is reason to believe that the EFTA court, at least in later decisions, will adjust its course to reflect the opinion of the EU court. The next question. Sorry. Are the network codes incorporated in the Norwegian legal system on the basis of the law that incorporated the third package into the EEA agreement? Given that these network codes are tertiary legislation and derived from the electricity and gas regulation, or what is the legal process through which Statnett, for instance, needs to comply with the codes? The present situation for the EEA agreement is that the third energy market package is now very recently, or is actually about to be incorporated into the EEA agreement. It was decided by the EEA Joint Committee to incorporate in 2017, but that is now subject to the decisions from national parliaments, where the Norwegian National Parliament has decided to accept implementation, and as far as I'm aware, I think that decision by the Icelandic Parliament is still awaiting, as far as I know. But I assume that it will be implemented. The network codes, however, have not been implemented yet, and under the EEA structure, that implementation will have to follow the same structure as the implementation of other secondary law, although you could call this tertiary law. So the network codes will have to be decided for implementation by the EEA Joint Committee, just as other pieces of legislation, directives and regulations. And when that will happen, I do not think has been decided upon yet, but I'm sure that it is a process starting now. So the question is, what happens in the meantime before implementation? Well, formally, Norway and Iceland, for that matter, are not legally required to implement the network codes. That will happen after it has been implemented into the EEA agreement. And hence Statnett, for example, is not at present legally required in Norway to follow the network codes. So we get this problem of a time lag, really, where different provisions may apply in EU countries and non-EU countries. And the same could be the case for the Energy Community Treaty before it is implemented there, in the time period until it is implemented. And I think this is a challenge that it is difficult to do anything about this, because formally it will be the question of a new treaty amendment when these pieces of legislation are implemented, and that will necessarily have to take some time, because all of this needs to be reviewed. And since the network codes are so extensive, I would assume that quite some time is needed to implement them under the EEA agreement, for example. Next question, does the existing law have a place to accommodate African countries in the future? How will the existing EU energy law apply for non-EU countries outside Europe to develop a power pool with African countries on the northern part of Africa via Spain, Morocco? Well, at least as far as I know, but I may not have the full picture here, I should emphasize, but at least as far as I know, I'm not aware of any particular instruments to facilitate or include African countries at present. Whether that will be possible in the future or conceivable, I have no. I do not know. I think it will depend on also on how these markets develop and how the cooperation develop. A next question. In the future clean energy package, risk preparedness regulation gives a strong role to regional cooperation for security of supply. How do you see the role of EEA members in this context? Well, security of supply legislation raises some particular challenges under the EEA cooperation, and this has to do with the background that the EEA agreement incorporates the internal market for the EFTA states, but not necessarily other parts of the EU cooperation. And then the question arises whether, for example, security of supply motivated legislation adopted under the energy title of the Treaty of the Functioning of the European Union, whether that is actually legislation which is relevant under the EEA agreement and therefore should be implemented into the EEA agreement. In cases where the main motivation behind the EU legislation is really internal market, but it would also touch on security of supply. For example, in the prevailing legislation, you would typically have a number of provisions which sets out the main principles and then states that member states may exempt certain situations or actors for security of supply reasons. Well, then that's in essence internal market legislations, and it will be relevant under the EEA agreement and incorporated. But if you have legislation which is motivated primarily with security of supply, for example, the first gas security of supply directive, well, then it's not really an internal market piece of legislation, and it is not necessarily relevant. And the first security of a gas supply directive is an example. It was not implemented into the EEA agreement. So it will have to be carefully assessed then whether the risk preparedness regulation will actually be EEA relevant. And personally, I have not carried out that assessment yet, but that's an important question, which will have to be considered after then first adoption at EU level. I can see one more question at least here. Any thoughts on the Union's efforts to extend the Acquis to strategic partners who are not part of the Energy Community Treaty, i.e. Russia and its implementation? I do not have any specific thoughts on that at present. It's I'm sorry. I don't really have any particular thoughts on the issue. And, are there any further questions? I'm sorry if there are, if I've overseen or if I've skipped any questions here, but I hope that I've at least tried to answer the questions that have been posed. Yes, sorry, here there's one more question. You briefly mentioned that there was a heated debate in Norway. Does the role of ACER in drafting decisions to be taken up by the EFTA Surveillance Authority raise any constitutional challenges, and could it thus be challenged? Yes, this has actually raised a rather large constitutional debate. And the issue under the Norwegian constitution was in essence how to deal with this, how to vote on this in the Norwegian parliament. As a point of departure, in important treaty matters, the Norwegian Parliament votes with ordinary 50% majority. But then if there are situations where Norwegian decision-making powers are delegated to an international organization, where Norway is also part, and that competence is of some substance, then 3/4 qualified majorities, or a qualified majority is needed. Not a 3/4, but a qualified majority is needed. And in the parliament. And that was a huge debate whether that was necessary to address the current situation, where based on opinions from the legal service of Norwegian Ministry of Justice, it was assumed that only an ordinary majority was needed, and but it was a huge debate how to deal with this issue. I see one more question here. As we know, most of the guidelines will be implemented through methodologies. If the EU TSOs are obliged to conclude a methodology by the provisions of the network codes, where does the obligation of a Norwegian TSO derive from? Do they participate in the process of drafting of methodologies on a voluntary basis? Well, at the outset, yes. How to deal with these methodologies in an EEA context, I don't think has really been decided upon yet. To the extent that they should be legally binding methodologies, my initial thought is that, well, then they would also need to be particularly implemented as treaty texts, actually. Just as the network codes. But I think it remains to be seen how these methodologies will be dealt with.
Thank you very much, Henrik, for your interesting session, and thank you all for joining this webinar, which I remind you is only the first appointment of a series of webinars. So let me also remind you that the next appointment is on the 18th of June. Thank you very much for your participation.